Good afternoon. I'm Kathy Hoover with the Social and Health Services Olympia Division. And with me are my colleagues Bruce Work and Tim Crandall, also from the Social and Health Services Division. I understand that I'm introducing them and I don't have their bios, so I'll just tell you what I know about them. They are both delightful people. Bruce is in our, we use acronyms, CDJ section, and I frankly don't remember what children's, developmental disabilities, and juvenile rehab section. And he advises primarily the Division of Developmental Disabilities within DSHS, which has a ton of Medicaid overlay. And Tim Crandall is in our MAS section, medical and aging section, right? We advise the Medicaid program and the Aging and Disability Services Administration, and I'm in that section as well. Tim and I primarily focus on Medicaid issues. And just a little note about the Social and Health Services Division, because anytime I go out in other divisions or am at the AG conference, people say, oh, do you do juvenile cases? And I don't, and most of us don't. A lot of us focus on Medicaid, and so that sounds very exciting with national health care and all of these reforms. And mostly what we do are cases about money. Because Medicaid is a, Bill Stevens, how many billion-dollar program? $4 billion program. And so a lot of people, a lot of agencies, entities, hospitals, care facilities see a big dollar sign on Medicaid's back. And that's what we're going to talk to you today about, money. Emergency rules in the new economic era. So, this is primarily focused on the new provision in the APA that was adopted a couple years ago when the economy started taking a downturn. And agencies were finding that they were running out of money for DSHS, I know, when we had big program lawsuits, we often had a settlement range in big program cases, $10 to $15 million. And so in a lot of those cases, we could get a huge case down to $10 to $15 million, and the agency could go back in the supplemental budgeting process and get that settlement covered. Now, increasingly, every single dollar counts. And so a couple years ago, the APA emergency rulemaking provision was modified to add an emergency budget provision, allowing an agency in certain circumstances to adopt an emergency rule to address a budget issue. So just to go over, again, all of the bases for emergency rulemaking. And I don't know about your agencies, but in DSHS, we are asked to look at quite a few emergency rules. And a lot of them are very, very routine and non-controversial. For example, if the federal government changes an appropriation or changes a rule on the Medicaid program, then it used to be DSHS, now it's Healthcare Authority, that administers the Medicaid program, would routinely pass an emergency rule to comply with that federal law change. Very non-controversial, or to make a budget change that was passed in the regular course. They could do emergency rulemaking to match up. So there are three bases for emergency rules under the APA. There has to be a good cause finding, and the first basis is that the emergency rule is necessary to pass on a quick time frame, shorter than the normal course of rulemaking, for the preservation of public health, safety, or the general welfare. The next basis is that the agency for good cause finds that the state or federal law or a federal deadline requires the adoption of emergency rule. Again, this is the one that we see our clients use all the time at DSHS and the Healthcare Authority. And then we have the new one that until these cases we think, or in our experience, has been untested. And this is that the agency for good cause finds that in order to implement the requirements or reductions in appropriations enacted in any of these fiscal years, it's necessary to make a change on an emergency basis. So again, there are procedural requirements. They aren't stringent, but for emergency rulemaking, there are procedural requirements, and there has to be a finding, the good cause finding, referenced in those provisions of the APA, supporting the bases for emergency rulemaking, and a concise statement of the reasons for the finding needs to be filed at the same time. And so in the cases that we're going to talk about, the statements are very concise, and we can talk about what seems to be sufficient to satisfy that concise statement requirement. The rule, an emergency rule, takes place immediately upon filing, or the agency can name a later date, which was the case in one of the cases that we're going to discuss. And an emergency rule can last no more than 120 days, but there are exceptions. If conditions change or if the agency begins permanent rulemaking and is actively undertaking permanent rulemaking, then the emergency rule can last more than 120 days. The agency can drop it again and extend it for another 120 days. And we usually see emergency rules or rules challenged in a judicial review process, but in preparing for this, I found that you can also do a petition to repeal an emergency rule that's adopted by one of these agencies on the slide. And you have to act quickly. Any person can do it within 7 days, and then there's a process that the governor's office has to follow. And the only basis to file a petition to repeal is that the emergency conditions, so the petitioner would contend and show that the emergency conditions that the agency cited in its good cause finding actually don't exist. And note that even this petition doesn't, even if it's granted, it doesn't prevent a permanent rule that the agency adopts through the normal course of permanent rulemaking from taking place. Because again, the basis is there's no emergency. So the next question that we hope to sort of illustrate for you is to give you an idea under this new rule, what constitutes an emergency to support one of these emergency budget cuts. That leads us to Tim Crandall.
Good afternoon. So mine is the first of three tales of woe. What happens when the client largely disregards the advice, the sage advice of their Assistant Attorney General, and do it their way. American College of Emergency Physicians versus the Healthcare Authority is the case that I'm here to talk about. By way of a little background, though, let's circle up above the United States and look to see common themes. Emergency rooms are expanding. It's big business. It's good business for the medical professions. Aggressive building and marketing of emergency rooms. No waiting. Come in and see us now. We can take care of you. But all of that's very expensive, and that needs a lot of clients to pay the mortgage on the building and the new equipment. So we have a national movement pretty much running against the attempt by our Medicaid program to limit the amount of emergency room usage. Very expensive use for a common cold, for a sunburn, for a bee sting. You should go to your primary care physician, not to the emergency room. For some time, the Chief Medical Officer, Dr. Jeff Thompson at the Medicaid program, had been working with other states and even the American College of Emergency Physicians and the various medical associations to cut back on pretty much the misuse of emergency room facilities. Dr. Thompson got the ear of the legislature and said we can save about $31 million if we control the unnecessary use of the emergency rooms. And as a consequence, in the budget, there is the mandate that there shall be some attempts to collaborate cooperatively with the medical associations to try to work on a list of diagnoses that will be deemed non-emergency, and to work on a set of retroactive review procedures to basically audit and take back some of the money paid to the emergency rooms for non-emergency conditions. This became known as the list of diagnoses. That was the subject of great contention. The emergency room docs wanted to see that list as a presumptive, I will not be paid if I employ this diagnosis, whereas the program was very clear that the list and the diagnosis itself is the first step in an analytic process that ultimately determines payment. And working closely with the associations, HCA, the Healthcare Authority, came up with a list of exceptions and a prior authorization process that put the emergency rooms in the driver's seat when it came to billing and being paid. But the attempt at collaboration failed. The definition of collaboration from the associations was their way or the highway. Tempers flared, threats of lawsuit were heard. This attempt at stakeholdering, which in a sense kind of looks like the stakeholdering that you have during the course of regular rulemaking, wasn't really working out that well. The Healthcare Authority had the responsibility to do what the legislature required, so in late September, the Healthcare Authority puts together an emergency rule that limits visits to 3 non-emergency visits per year per client. The fourth and thereafter are, conceivably could be billed to the patient. And it was at that point that the American College of Emergency Room Physicians, the Washington State Medical Association, the Washington State Hospital Association, and Seattle Children's Hospital all filed a rule challenge in front of Judge Casey at Thurston County Superior Court, seeking a declaratory judgment and a stay of the emergency rule. So, as you may or may not know, Healthcare Authority administers our Medicaid program. It was DSHS before the merger of last year. Having to effectuate budget cuts, this attempt at $31 million of savings was one of the many ways that the Healthcare Authority planned to meet the legislative goals. An awful lot of work went into this overall idea of limiting emergency room usage. Although the average Medicaid recipient uses an emergency room less than 3 times a year, there are other categories of clients who visit the emergency room excessively, such as clients who visited the emergency room more than 11 times in 2010 accounted for 32% of total visit counts. So you have a very focused cadre of individuals, basically, that are misusing the emergency room at tremendous cost to the Medicaid program. So we have the challenge to the emergency room by the listed petitioners, as I've previously identified them. Going back in time to May and June of 2010, where you had the knowledge that this was all coming down the pike. Did the healthcare authority at that time begin any rulemaking at all? Did they seek an emergency rule, knowing that some rule would have to be promulgated in order to address this legislative demand? No, there was no emergency rule activity back in May and June. Did it engage in any permanent rulemaking? No. It was engaged in stakeholdering pursuant to a close collaboration requirement from the legislature, which HCA felt it had to do. Its position back at that time was that how can we draft a rule unless and until we know what that rule covers, and that's what this close collaboration with the stakeholders as required by the legislature was all about. So no emergency rule activity and no permanent rule activity until waiting to adopt on an emergency basis at the end of September, effective the 1st of October, the emergency rule, which is what caused the firestorm. So the rule limited coverage of emergency room visits to 3 non-emergency visits per year. Right here in the operating budget, that limitation. After that 3rd non-emergency visit, the client could be billed. As I previously said, there's a lengthy list of exceptions and prior authorization procedures, which was designed to not interfere with those truly in need of the emergency care. And it should be stated clearly that any emergency was still going to be treated as such. It was trying to determine what types of diagnoses indicate non-emergencies that could be treated at an urgent care clinic or a primary care physician's office was the subject of this emergency rule. In the emergency rule, emergency is not defined, though there are numerous other existing WAC provisions that clearly spell out the loss of life or limb or the failure of an organ or something disastrous is going to happen to you. That's what an emergency situation looks like, not a sunburn or a bee sting, a headache, and the like. So how did the authority justify this emergency rulemaking? Basically, I'm looking at the rulemaking order, the CR 103E here. All 3 boxes are checked. You know, the one for the preservation of the public health, the one regarding the need to be in accordance with federal rules or deadlines to receive money, and lastly, the one that Kathy has mentioned. In order to implement the requirements, reductions, and appropriations which necessitates the need for immediate adoption, amendment, or repeal, that observing the time requirements would be contrary to the fiscal needs. So what does ACEP say in its justification? It basically begins with a recitation of what the state legislature had required of HCA to collaborate closely with the hospitals associations and others, identifying those diagnosis codes and retroactive review procedures. That's all kind of clearing one's throat. And finally, in the last sentence, is where I think is the only purchase that I and Bill Stevens had in terms of defending this, was delay in adoption would jeopardize the state's ability to provide health care coverage for patients requiring emergency treatment. That, as you can see, is rather conclusory. It offers the court in its review little to hang its hat on by way of specific explanation of why notice and comment and formal rulemaking is not needed. So in support of the rules, going back in time a little bit, the Healthcare Authority had prepared lengthy reports showing the high incidence of expensive ER usage for non-medical emergencies. There was a tremendous correlation between drug-seeking behavior and frequent visits to the emergency room or emergency rooms around the state. You have the drug-seeking behavior, you have mental illness, and you have the unnecessary use of the emergency room facilities, basically spurring the Medicaid program to address this in some meaningful way. There was a list out of New York State, the New York experience, that Dr. Thompson employed in setting out that list of diagnoses. And of course that was what the petitioners found to be most difficult for them to swallow, because they have no input, they said, in what that list looked like, even though in fact they did have input, but they wanted no list whatsoever. So how did they challenge? There we go. No emergency exists to justify the use of the rule that the Healthcare Authority had improperly brought about this situation. Of course, in their briefing, this was Bennett and Bigelow, Mike Madden speaking here, the agency's reasons for declaring an emergency must be truly emergent and persuasive, must be more than a mere statement of the motivations. You can't really parrot the language of the emergency rule. You must articulate a credible ground for believing that the emergency procedures were necessary for preservation of public health, safety, and welfare, and that observance of the requirements of notice and comment needed to be foregone because it was in the interest of the public to do so. Looking back on delay in adoption of this rule would jeopardize the state's stability. That's all we had to hang our hat on in terms of satisfying the court-imposed test. And this was Mousy v. Gibbs 44 Wash Act, 1986. That was the only case that's directly on point. So, and of course they focused that healthcare knew about all of this way back in May and June and did nothing until the 11th hour. So we are, before Judge Casey, there are numerous substantive issues involved in this case. The issue as to emergency rule was but one of, I think, 10 discrete issues that we had to address. Mike Madden got about 5 minutes into his delivery when she says, "I want to hear about the emergency rule." And he gives his spiel, and then she passes it to me and says, "Mr. Crandall, I want to hear from you. What's your defense?" So I basically went through this whole stakeholdering idea and how could the agency know what a rule would look like until it had collaborated closely, in anticipation of a rule. That didn't fly, obviously. The court basically rules that you can't create your own emergency by delaying rulemaking. This was basically of HCA's own making. In fact, I have the court's order here. The HCA had a reasonable amount of time within which to adopt a permanent rule addressing limitations on coverage for emergency room visits, and that by following this emergency rule procedure, it utilized that emergency rule process when no emergency existed, and she stayed the operation of the emergency rule. So what have we learned? At the time that the agency becomes aware of an issue such as this, appropriations and or receives budget direction from the legislature, to analyze to see whether there should be a permanent rule started at that time. whether you should do an emergency rule at the same time as you're starting your permanent rule process. That would be our advice. There certainly was a legitimate basis to adopt a substantive rule. The timing was wrong. And since emergency rules are all about timing, you have to use that emergency tool at the time when you're first aware of the emergency, or you will suffer the consequences as did the healthcare bill. So, passing it on now to Bruce, M.T.E versus DSHS. Yes.
I didn't know you were getting questions now, but I have one question about October. Why is it that the agency thought that they had to do this by October? And I guess my comment to that was June to October doesn't sound like a really long time to get permanent rules in place, so they were bound to be contention. So would you advise doing the emergency rules just in anticipation of the fact that you're not going to get the permanent rules in place this time, or does it for that time?
Right, but you can be sort of re-upping your emergency rule period if, in fact, you are engaged in permanent rulemaking. So you would have a rule in place the first time you learn of the need for the rule while you're working towards your permanent rule. And why choose October? That's a good question. That was challenged by the petitioners. There was no legislative directive that, as of October 1, you shall have a limitation as to 3 non-emergency visits. It was basically HCA's belief that they had to do something. The legislature had told them to start the savings, get that $31 million. All the stakeholdering and close collaboration was going nowhere. So basically, as of October 1, we're going to impose what the legislature has already expected us to save, begin that process. So in a sense, it can be seen as an arbitrary date. But it was a date also, I think, clearly seen by HCA as when the lawsuit would happen. So the collaboration wasn't working. There were threats of suits. In fact, there was some ugly body language, and at one point, whether fisticuffs might come into play during one of these meetings. These doctors are feisty. Anyway, thank you.
Okay, so I'm not quite sure how to begin to introduce this. I'll start wherever this begins here. We have to go back. To understand the M.T.E case, you have to go back to learn how to work with them first. Okay, let's go back to the Samantha A case, which came out, which was issued in May of last year. And can people hear me? M.T.E is the initials of a DSHS client. So the Samantha A case is about eligibility for certain kind of DSHS services called personal care services. Personal care services are those kinds of services that people with disabilities require to assist them with day-to-day activities like bathing, eating, dressing, and so forth. And there was a rule, a DSHS rule, that specifically applied to children with disabilities. And what the rule did was to say that for children who live with their parents, that the parents had a certain level of responsibility for providing the personal care services to their kids, and also children of a certain age, so very young children, whether they have a disability or not, require the same services that children without disabilities require. So the department doesn't want to pay or didn't pay for services that all kids need at a certain age, and they didn't pay for services that could be provided by their natural parents. So that's what the rule was about. We obviously didn't do a very good job of explaining it because the Supreme Court, in a 5-4 decision in Samantha A, felt that that was an inappropriate use of Medicaid money, that it violated what's known as the Medicaid comparability requirement. So basically, the Supreme Court felt that the children weren't treated in a way that was comparable to adults, essentially. We often felt that we got a very bad deal timing-wise on the Samantha A case because it was a 5-4 decision. About a month later, Justice Sanders was no longer on the bench. We tend to believe that if we had the case heard a month later, we might have gotten a different decision. But in any case, that's the way it came out. Two of the justices, actually, there's a precedent case called Jenkins to Samantha A. Two of the justices felt that not only should the decision have gone in the favor of the department, but that the previous decision, the Jenkins decision, should have been overturned. So we felt like we had a fairly strong case for reconsideration. It was a 5-4 decision, 4 solidly dissenting justices, and a justice who was about to leave, being a sort of tiebreaker on the other side. So we moved for reconsideration, and that was back in May. Very shortly thereafter, one of the attorneys for Samantha A filed a case in Thurston County Superior Court, which, as luck would have it, was assigned to Judge Casey, and basically saying, that the department should immediately stop using the rule that was essentially invalidated in Samantha A. So we basically said, well, no, nothing should happen right now because we've moved for reconsideration. The court may very well reconsider its decision, and so nothing actually happened until a decision denying reconsideration was issued late in September. Okay. So essentially what the plaintiffs were saying in M.T.E. was that the rule should immediately be, invalidated rule, the rule that was invalidated in Samantha A, should immediately be revoked, and the department should initiate permanent rulemaking if it needed to come up with something that would replace it, but essentially plaintiffs didn't feel that there was any need to replace it. In any case, they felt that if you got rid of what was known as the Children's Personal Care Rule, that everybody could be assessed in the same way under the same set of rules. You're looking at me as if I'm saying, okay, just checking it out. Let's see. So what happened then is that when the Supreme Court issued its decision denying reconsideration, then things started happening fairly quickly in M.T.E. The department did not develop new rules during the long interim, but did start discussing the potential to develop new rules. The essential problem with the Children's Personal Care Rule was that it had what was known as irrebuttable presumptions. So it said that the department was making these assumptions about children, and there was no way that parents could say, no way, my kid is different than other kids, or I can't provide the kind of care that other parents can provide. So the way we understood the Supreme Court decision was to say, well, it wasn't so much that you couldn't look at the age of the child or the parent's responsibility, but you couldn't make irrebuttable presumptions about it. So the department started to develop rules that said, okay, this won't be an irrebuttable presumption, but we are going to make the same presumption, essentially the same presumption, but if you think your situation differs from other people, you can go ahead and challenge that. So they weren't irrebuttable presumptions anymore. So the M.T.E. case then, in October, or early October, plaintiffs at that point moved to immediately get the department to stop implementing the Children's Personal Care Rule, which from their perspective meant, okay, you stop using that, children get essentially, this is where it gets complicated as a way of describing it in a way that's easy to understand. The Children's Personal Care Rule reduced personal care hours from what is known as base hours. So every child was authorized to receive a certain number of base hours, and then, depending on their parents' availability and their age, hours would be reduced from the base hours. And so what the plaintiffs were saying in M.T.E. is, well, you get rid of that, and all children get all their base hours. And we said, well, you can't do that, because what that would mean is that parents had no responsibility. Parents could say, well, I don't want to do anything for my child, and the state would have to come in and pay for that care. So what the dilemma was is, what do you do in the interim between the time that you invalidate this one rule and you develop other rules that go into its place? The plaintiff's position was, you don't do anything. You just, provide all the base hours to children that they were authorized to receive. Our position was, no, you actually can't do that. You have to continue to apply the old rule until new rules come into place, until children can be reevaluated under the new rules. So that's what, there followed a series of hearings and motions and so forth over the course of October, in which essentially that was the issue. The issue was what to do in the interim. And the plaintiffs essentially said, don't do anything. We said, no, apply the old rule until you can reevaluate and we can put in some emergency rules. New emergency rules were, in fact, adopted right at the beginning of October. For a variety of reasons, they weren't. Anyway, I'll get to that. It gets more complicated. Okay, so the new emergency rules were adopted, and the reasons given were 1A and 1B. Interestingly, the department didn't cite as authority 1C, the budget emergency, which I think we could have done. Essentially, what the department said was that, well, there's a public health issue here, because what happens is if you authorize all personal care hours for children, you're going to be taking money away from adults, because there's only so much available personal care money to go around to everybody. So if you reallocate it to children, you're taking it away from adults, that's a public health issue. It was also necessary to comply with state law, which is the law in Samantha A. Samantha A said this one rule was invalidated. In order then to implement that, we had to adopt another emergency rule. I think the department could have said that there was a budget emergency, because of for the same reason that there's a public health issue. There's only so much money, you have to allocate it in a way that's consistent with the budget. You can't go beyond the budget. So this was the explanation for the emergency rulemaking. And you can read it, but what I think you'll notice as you read it is that it doesn't really say very much. The department must revise its assessment process as soon as possible in order to allocate personal care services for children on a more individualized basis. The emergency rule is necessary in order to implement as soon as possible the state Supreme Court decision in Samantha A. So, we're sort of saying, well, we just have to do it because there needs to be something in place of what isn't there after the Samantha A decision. What happened after that was that the department started to look at what the actual costs of implementing of just simply taking away the rule and leaving nothing in its place. And so we were able to start to get before the court that simply invalidating the rule, putting nothing in its place, would be putting the department in danger of exceeding its allocation of legislative funding for personal care services. There was a series of hearings, as I say, where the plaintiffs were essentially saying, do this now, do it now. and court ordered the department to do it now. And we were sort of saying, well, we're doing it as quickly as we can, but we can't do it immediately. So the sort of question of what is immediate came up. I remember we got an email from plaintiff's counsel saying, essentially, don't you understand the meaning of immediate? Immediate means now, and sort of giving a dictionary definition of what immediate means. I had hoped to be able to show the series of orders that came out of Judge Casey's court, because it's kind of, just looking at them visually is kind of interesting. When the first motion for enjoining the children's personal care rule was heard, the plaintiffs put in a proposed order. You're not going to be able to see it because I'm technologically challenged enough to be unable to put it up on a PowerPoint, but I can maybe hold this up and describe what it is. This is the first order that was issued in early October, and was it early November? This is early November, sorry. So in early November, this is the first order that was issued. And there's very little amendment to the plaintiff's proposed order. There's a couple of words that we changed and so forth. But the judge was pretty convinced that the department wasn't doing what it was supposed to do. The department was the rule was invalidated. The judge felt, well, it's invalidated. You just get rid of it and you stop using it immediately, now. And then we moved to reconsideration to try to explain why that wasn't really possible. You couldn't just get rid of it. There's nothing to put in its place. And so the plaintiffs then moved for a remedial sanction. And by this time it was, that one was November 4th, this is November 22nd. And I doubt that you can see this in the back, but this is the second proposed order. As you could see, if you were close enough to see it, it's heavily changed. There's a very large portion of it are redacted altogether. And what that really was about was that the judge started, at least in retrospect, it's possible to see that what was happening for Judge Casey was she was starting to get that, in fact, you couldn't just get rid of an order, get rid of a rule, and have nothing in its place. And then finally, the plaintiffs moved to sanction the department again. In fact, they suggested that if the department didn't immediately start providing all base hours to children, that perhaps Secretary Dreyfus, the Secretary of DSHS, should face sanctions, including imprisonment. So they were getting fairly hot up about it. But then, in early December, we had another hearing, essentially on those kinds of issues, also where plaintiffs were attempting to stay the implementation of the new emergency rules. And this order, you can see, is not redacted at all. And the reason it's not redacted, and the reason there's no changes to it, is because the order that was submitted by the plaintiffs was meaningless. They had to leave and submit an order that was consistent with the judge's new order. And the judge's new order essentially said, okay, you can go ahead and keep applying the old invalidated rule, but people can ask for all their base hours, but they have to ask for it. And so there needs to be some sort of affirmative action taken by recipients in order to get all their base hours, which is somewhat more manageable. She also said that the department could expedite the new assessments for anybody who asked for all their base hours so that those people could be assessed immediately. So essentially, I think she felt like she couldn't ignore the Samantha A decision. She had to order the department to cease implementation or cease implementation of the invalidated rule. But she sort of started to recognize that the immediate revocation of the rule was not possible. in large part of that had to do with the fact that she understood that there's a limited pot of money, that you can't exceed that the cost of simply providing all base hours to children would have the effect of reducing hours, reducing services for other groups of DSHS clients. One of the things that in attempting to stay the emergency rules, I don't know if anybody's ever actually petitioned the governor. Do you know if anybody ever has? The method in the rule, the method in the statute for challenging an emergency rule is to petition the governor. Plaintiffs in this case didn't petition the governor. What they did is to go back to court and ask for a stay of the emergency rules. So essentially stay of an agency action. So they said, well, look, the Samantha A decision came out in May. You're issuing these rules on an emergency basis out here in November or October. There's obviously no emergency. You've had plenty of time to submit these rules. And basically what we said, and Judge Casey agreed, was, well, no, we actually moved for reconsideration. It would have been inappropriate to issue any emergency rules right after the Samantha A decision came out, because that could, they may well have reconsidered. There was a very good case for reconsideration. And if they reconsidered and changed, not invalidated the rule, there'd be no purpose to have issued any emergency rules. So this is what Judge Casey said eventually in the last hearing that we had. I'm satisfied that personal care services can be allocated and should be allocated based on the available funds. So the financial situation does create an emergency for adopting emergency rules. To the extent that the rule is adopted on an emergency basis to go forward with individualized assessments for children, I'm not going to stay as application. So over the course of a month and a half, I think she really came to understand what the problem here was and why the emergency rules were appropriate. So I don't know whether this is really unlike a CEP, but if one thing I think is clearly different is that Judge Casey, after ACEP.
I just have a question about the findings back on the last one.
Sure.
Because I heard you say that the agency's rule adoption order didn't rely on the funding component of the statute.
Well, it didn't check the box. It didn't. We argued it, but in their submission of the emergency rule, you say whether or not the emergency is going to be adopted based on A, B, or C. Didn't check C. We argued it. Didn't come up as a particular issue that it was not checked on the submission, but it was a reason that the court accepted. And basically, I can't remember now if we even discussed it at all. We might have said, so what? We can go back and change that. We can resubmit it, checking the appropriate box. And I think, the difference maybe in large part between ACEP and M.T.E. had to do with the fact that, this is afterwards. Judge Casey had a chance to really think about this in a different way, and it may be that she had just moved to a different place after that earlier case. But I think she also saw that there probably wasn't any good reason to have filed an emergency rule right after the Samantha A decision. So the lessons learned, as I say, all boxes should have been checked, certainly in this case. And it may be a general rule to do that if there's any colorable argument to check all boxes, simply because I suppose it could have come back to bite us that subsection C wasn't checked, and how come you didn't check that when you're arguing it. So we probably should have just gone ahead and checked it. It says only one box was checked, but I think that's inaccurate. It was actually two. It was A and B were both. So obviously ensure that emergency rulemaking complies with all procedural requirements. The concise statement, well, we had one there. It was better than how much is too much, how much is too little. Well, we know how much is too little. In the Mousy decision that Kim cited, the proponents of the rule simply said, well, they just used the language of 3405, 350, and the court said, well, that's not enough. You got to say something more than that. We said, or the DSHS said, something more than that. Maybe not all it should have said. It probably could have gone into somewhat greater depth than simply, well, Samantha A was passed, so we have to pass these rules. Samantha A was decided, so we have to pass these rules. I don't know how much is too much. Maybe there is no too much. It's probably a good idea to give a fair amount of explanation. I think we've already covered that. Yeah, I mean, sort of what I was saying before. We had to have a new rule at that point. We couldn't simply allow that vacuum to continue because it would have essentially broken the bank of the department. Go into that. So that's about all I have to say, unless other people have questions about it. Yes.
What was the time frame between the denial of reconsideration and the acceptance?
I think it was about a month. Do you remember that? So the denial was about the 30th of September, and the new rules were adopted on the 4th of September. Gail?
Could you just go back if I could grab that slide?
Sure.
How much flexibility would you perceive there to be in terms of learning that you not check the box and just saying, okay, we're going to do another one, another emergency rule, do it right this time?
I would say that how much have you convinced the judge of the validity of the rule itself? If she's pretty convinced that you've done the right thing, I would guess that, not having checked the right box is not going to be, at least from this experience, I would say, no, not a big problem. You can get a fair amount of consideration from your judge if the judge is already so inclined. That's kind of the way it looks to me. I don't know whether you guys see it differently. Kathy's going to talk about that.
So the next case is SEIU versus Arnold Williams. By this time, Secretary Dreyfus had left and gone back to Wisconsin, and Robin Arnold Williams was brought back from, I think she had been at OFM, to be the Secretary of DSHS again. So she promptly was sued. Excuse me. So this was the next round of Samantha A, M.T.E, and now SEIU. And why are the SEIU suing DSHS now? Because the personal care that's supplied to these Medicaid clients is provided by individual care providers that are represented by the union for wages and working conditions. So they're not considered state employees for any other purpose. There's a special statute that says for purposes of wages, working conditions, and benefits, they're represented by the union, and the statute, thank goodness, retains management of the Medicaid program to DSHS and now Healthcare Authority. Otherwise, I'm sure the union would be very happy to come in and manage the Medicaid program. And actually, that's another issue that we're fighting about right now in SEIU, a whole other CLE. Catch me after we have that summary judgment motion. So the SEIU came in, and they're not happy because as a result of more fallout from Samantha A and M.T.E, you heard Bruce talk about, we're now having to do all sorts of things to make Judge Casey happy, restore hours for children, do very quick individualized assessments for, I think is it 3,000 or is it 6,000 kids? 3,000 kids in a week, and build back up their hours. So the agency is trying to figure out how much is this going to cost? How many kids are going to do as Judge Casey required DSH to give the hours back, ask for the hours to be given back. They had to get a notice saying, hey, by the way, do you want more hours? Call us. And so the agency knew they were going to have increased costs throughout this whole process. And it was trying to figure out what the costs were. They were trying to project how many people are going to request the additional hours. When we get done with these new assessments, what are those hours going to look like? And they had some information to help them figure this out, but they had 3 estimates that they thought were likely: a low-cost estimate, a medium-cost estimate, and a high-cost estimate. And based on everything that it knew and its data, they thought that the medium-cost estimate was the most likely amount of increased costs that they would face through the end of the biennium. And that was going to put them over their budget allocation for personal care. And so what to do? They had to look around at all of the programs and figure out how to cut those costs. And they cut them in 2 different ways. One was to do another thing on children's assessments, and that's yet another lawsuit, DB, that Bruce and Ed D are defending. And they also did another cut that is being challenged in SEIU. So again, this is just the next slide. It's just a summary of the problem. We know we're going to increase experience costs. How do we save that money? So in the SEIU cut that is challenging the SEIU lawsuit, what the agency decided was not only do some clients get their base hours adjusted for the supports they might get outside of the Medicaid system, some clients get a bonus. They get bonus hours, and they're tacked on fairly without much analysis. If certain conditions exist, they get these bonus hours. So clients who reside more than, I think it's 45 minutes from a drugstore or a grocery store get a bonus, because it's assumed that their caregivers, if they assist them with those tasks, will incur some time driving, significant time driving to the store, or at least driving out to their house to bring them their groceries or their medications. And also, clients who don't have laundry in their home automatically get an add-on for laundry, because again, it's assumed that if a caregiver helps the clients with laundry, they're going to have to haul this laundry somewhere to the laundromat or to their home, if that's allowed, I don't know, and haul it back. So it's an automatic add-on. And so in this new emergency budget cut, those add-ons were eliminated by emergency rule. And to be clear, the agency had money at the time, but it was projecting by the end of the biennium, if we don't impose these cuts, we're going to be in very hot water. We're going to be way over budget. And so what we'd like to do now when we project these budget overruns is to adopt the cuts now on an emergency basis And the reason why the agency wanted to do it now is because they had more time in the biennium to capture the cost savings. And so the cuts could be smaller over a longer period of time instead of getting towards the very end of the biennium and then saying to all clients, guess what? We can't afford the personal care program for the next 3 months. You're on your own. So that was kind of the internal thinking at the time that the agency was formulating its decision to adopt an emergency budget cut. So again, the medium cost estimate was the one that the agency projected as the most likely, and that set forth the amount of money that they need to recapture through the end of the biennium. So, the rulemaking order, this gets very complicated because this rulemaking, this emergency rule was actually part of a series of 5 emergency rules that I won't even bore you with the details, but we had to explain this to the court because there were bits and pieces of the emergency budget cut and the children's changes spanned 5 emergency rules. And some of them, one of them was just a rule on definitions. Try to explain how a rule on definitions has to be adopted on an emergency rule basis. That was interesting. In this particular rulemaking order, the emergency budget cut provision was checked. We got the right box checked. But because it was also tied up with 5 other emergency rules, I think we could have checked all 3 boxes. Yes, there's a question.
Why did you put all the rules that you needed in one rule?
I'm getting to that. Because the question was, why didn't you put all of these rules in one rulemaking package? And the answer is because the AGO was not involved at that time. Had the AGO been involved, they would have done it perfectly. We all know that. No, it's partly because things were happening quickly, and the agency was reacting. And you get a high five for that. And partly because I think at the time some of the relationship wasn't seen. So on the emergency rulemaking order, the 103E, the agency also set forth a little bit more explanation of why this had to be cut, why these add-on hours had to be cut on an emergency basis. So again, then the union filed their lawsuit, and they challenged the emergency rule eliminating this add-on benefit, and part of one of the children's assessment rules, the definition rule, in fact, that was related to implementing Samantha A and M.T.E. The union thought that definition change imposed a further budget cut, which it doesn't. And I don't think that we've convinced them of that yet, but it truly doesn't. So they were looking at cuts, what they thought were cuts and where it would hit their bottom line, and that's what they thought to challenge. So there were 2 rulemaking orders, emergency rulemaking orders at issue in our case. They're related to all these other emergency rules, and they're all tied up. And they took a look at these orders because as the agency was adopting this series of emergency rules, it just checked the boxes that it thought applied to that new emergency rule. Now, in some cases, they were incorporating a prior emergency rule in the same rulemaking order because they didn't want to lose that language. So they're thinking, okay, well, we adopted that emergency rule in October. We're doing another one in November. We're going to put that into our November rulemaking order because we don't want to lose those changes. And we're going to make some new changes in our November order. So its rulemaking order was providing explanation only for the most recent change, not the prior ones that they were sweeping along as we move along. So the SEIU comes in and I think legitimately says, for practical purposes, they knew what was going on, why and when. But they come into court and they say, my goodness, I look at your emergency rulemaking orders and I cannot tell what's going on. I don't know why you're doing this. And it looks like you're changing your bases for emergency rulemaking as you go along. Now, to the casual observer, that would appear to be true. So we had to worry because we're going to have a judge look at this now. But the union had been along with DSHS the whole way. So, I mean, it was kind of disingenuous to say it did not understand what was going on, why and when. But, you know, if you take a look at the requirements in the APA and the requirements to make a concise statement and check the right boxes and give the right bases for your rulemaking, they had a point. So that's what they said. And then they said, and bottom line, there's no emergency that justifies DSHS imposing cuts. Can't do it. So, our star, what's your name? Phil? Last name? Oh, Phil Ferris.
Oh.
See, I know so many people's names just on paper, but not by sight. You anticipated this as well. So okay, give you a little war story. We got served with a lawsuit. We can tell it's related to these emergency rules, and so we start pulling up. And bless their hearts, Bruce and Ed are working on like 6 different lawsuits right now and going up to the 9th Circuit. And they said, "Do you think you guys can handle this one?" And we said, "Okay." I mean, I guess, you know, fine. Six federal lawsuits is not enough. Okay. You know, they are valiant soldiers, and we said, of course, we would be happy to take it up in our section. And then we started looking at the emergency rule-making orders, and we're like, they have a point. I mean, I can see when we talk to the agency, we can see what they're doing, but it took us, I think, 3 meetings because we're like, okay, go back to the office. Donna, do you understand what happened? I thought I did, but I don't. Go back, and then finally the light bulb went off. Oh, you know, especially when we pulled out the M.T.E. pleading notebooks, all 10 of them or something. These guys are having these motions. Bruce understated it. It was like every other day. And we saw just how fast and furiously things were moving. So what we did is file another rulemaking order. They're saying they don't understand. We're very happy to accommodate them. So they did another rulemaking order, and they laid out all of the changes in all 5 of the emergency rules, and they said this change is justified by this provision in the APA, and here's further explanation for it. This change is justified by this provision or these provisions in the APA, and here's further explanation for it. So they dropped these new CR 103Es to give the union all of the explanation it wanted. And believe me, our agency gave us pushback. The form doesn't have the space. So what? Add-on of addendum. And we, went up to the chain of command, and then you get to the right person in the management, and then suddenly your rule-making person's going, oh yeah, we'll have the addendum. So that's what we did, just basic arm twisting and up to chain of command. So, luckily, the agency also had dropped at least the 101s for permanent rulemaking, because this is going on over several months, and some of our 120 days are expiring for our emergency rules. But you can renew them under the APA when the agency has started doing permanent rulemaking, and luckily DSHS had. So, we had to go in. We got served we anticipated a TRO very quickly, and so we started working on it in anticipation of what we thought the union's law firm was going to argue. And didn't come for, just about 4 or 5 days out. And then we read in the newspaper that the union said that the hearing date, this was in February, and the newspaper, the union said the hearing date was March 16th, I think it was. So then we called the union's attorney and said, read in the newspaper that we've got a hearing on March 16th, so what is that? And they were properly chagrined and said, oh, yes, we were going to tell you about that. And I said, well, now we know, considering that your client talked to the Seattle Times, the cat's out of the bag. So they said, yes, we are going to do a stay hearing. And I don't know why they set it out that far. It was about a month out. And did they serve us early with their motion? No, we got to 5 days. So we continued working in the dark based on their complaint, what we thought that they were going to argue. And we developed our pleadings. We had the data that the emergency rule was based on. We had declarations from the people involved in the decision process. We had the orders, and we supplied the data. But it's not in the rulemaking record. And again, you go back to your agency rule people and you say, where's the data? And they say, we don't put that stuff in. We like to have the 101, the 102, or just in this case, the 103. That's program stuff. And then we say, well, I'm thinking back to my early days as a younger AG and those wonderful CLEs where Elliot first talks about, this is your chance when your agency gets to develop this beautiful record and everything they considered and all of their thought processes and their stakeholdering. This is where your rule file should contain all that. And, we're talking in our pleadings about this, costs going through the roof and going through the budget and breaking the law, and it's based on this data, and, and the data is beautiful, and this analysis, it's very well thought out. It's not in the record. But the plaintiffs have not raised, it legitimately and legally can be under the APA, we're getting that fixed. But it's another kind of cautionary tale, and we're still having fights with the rule people about it, and so we have to kind of get them on a sort of systemic basis to kind of be thinking differently about their rulemaking record and what they keep in it. And in this day, we used to get much more resistance when things were more just paper files, and there's really no excuse now that things are electronic. You can put things on disk. It's very easy. So we went to court on our stay motion, and we got Judge M.T.E, who also presided over the Rector trial, which was also on personal care assessments. And presently, the state owes about, $97 million for the damages and the interest, and that's on appeal. So, Scott M.T.E, is that a good thing or a bad thing? The good thing is he knows personal care, and this is so convoluted in assessments and care tools and blah, blah, blah. We know he'll absorb it quickly, and it's a short stay motion. But on the other hand, he's bound against the agency on these kind of rules where assumptions are made. So it turned out to be a good thing, though, because at one point the plaintiff's attorney was telling him how these rules operate, and he said, that is not what both experts in the Rector trial testified. And he proceeded to explain to them how the rule worked. And it wasn't the way that the attorney was arguing. And he came in, and we were on the regular Friday motions calendar, waded through everybody's motion, and then we went up and he's like, okay, what's going on? I've been sick last week. My wife had surgery. I haven't read anything. What's going on? And, this convoluted 5 rules and the new, it's like, But luckily, since he does know personal care and Medicaid and had sat through 4-week trial, he said, come back at 1:30. By 1:30, he knew it. I mean, it was absolutely stunning. And so we explained. They said, look, there's no emergency. They got money. They're not going over budget yet. There's no reason to adopt a budget cut right now. And by the way, if our workers' hours get cut, some of those workers won't get health care coverage. And I'm thinking, ain't our problem. They expressly got that out of the collective bargaining agreement. DSHS has nothing to do with it. Lucky for us. Used to be in the agreement. And they suggested that DSHS makes policy changes to cut millions of dollars. And we had to say, we're not going over budget yet, but we will. We believe in good faith. Look at the data. Look at the analysis. And so, right now, when the agency has reasonably anticipated a budget overrun, the agency adopted the emergency rule because we can take smaller cuts over a longer period of time, less impact for clients. And, we suggested, what is the union arguing? That we have to go up to the point where we run out of money and then we have no services? And so Judge M.T.E agreed with us. And also, you better believe we parroted Judge Casey's ruling in M.T.E, which it's kind of off the cuff. It's not a lot of thought on her part, where she said, I don't think the agency has to go over budget, and so you can adopt an emergency rule on that basis. And the plaintiffs didn't make great hay out of, look, she's just kind of throwing it off the cuff, but we parroted it thinking Judge M.T.E is not going to want to really argue with the reasoning of Judge Casey unless he can kind of articulate a basis for doing so. So we put on the slide his thought process, and he agreed with us. It's, when the agency reasonably anticipates a budget overrun, and he said, they don't have to know precisely. They can adopt one of these emergency budget cuts. I think it kind of, of course, depends on the facts in your case. But we actually had, like I said, a good analysis and a good thought behind the emergency rule. And going back to Phil's point, the plaintiffs argued, look at this mess of emergency rule-making orders. Look at this morass, these fives, the shifting, and he said, they filed the subsequent rulemaking order giving the explanation. And it was only two weeks after they did the budget cut, so it's not like you were, without notice for a long period of time. They promptly filed it. Thank goodness the union sued us then, and we told the department to do that. And so I think that substantial compliance is what is required here, and the agency did perform substantial compliance. Lessons learned. Check those boxes. We're now advising the agency, as Bruce said, if any and all that arguably apply, check them. Think about, don't just do it blindly. Think about the argument, whether an argument can be articulated under the 3 bases for emergency rulemaking, and have your agency check all that applies. And also remember, you have to have that good cause finding and the concise explanation of the good cause finding in the record. And don't take your agency's, doesn't fit. Don't be happy with that. If necessary, put an addendum, have the agency file an addendum providing that further explanation. You can't just parrot the language in the statute or make conclusory statements like Bruce suggested. And also, very importantly, at the same time the agency files the emergency rule, if they haven't already done so, suggest that they begin their permanent rulemaking. Because if the process gets complex and they need to extend their emergency rule for another 120 days, the only way they can do that is if conditions change or if they have already started the permanent rulemaking. So do both at or near the same time. And again, I already talked about this. It appears in the right circumstances when the agency projects, with a reasonable certainty that they're going to have a cost overrun. At least from SEIU so far, the court has said that seems like a good time for the agency to adopt that emergency budget cut. And again, as much analysis and numbers, data, number crunching data as possible, and it needs to go into the rulemaking file. So I don't have anything further questions. Kim?
Did the union challenge your data on the basis of what?
Did the union challenge the data on the basis that it wasn't in the rulemaking file? No. They didn't know what was in the rulemaking file, and it went and tried to get it to stay. We recently had our status conference a couple weeks ago, and they did not show up because it wasn't on their calendar. So we called them, and the judicial assistant said, "You didn't get the record in." And they're like, "What? The record?" And so we explained, this is a rulemaking challenge, so you've got to get the rule file in the record. And I said, I'll do it for you. Oh, thank you, says plaintiff's attorney. So we've got copies, and we got copies of the data and some other studies that the department had done. And I emailed him this week and said, okay, I'm going to send the copies to you. And the way we did this before on a substantive rule challenges, we just entered into a stipulation that this is the agency record, this is the record on review. And I've got a form for that, so I'll send it to you. Hold your breath. Now, again, legitimately, all of that stuff can come in and should come in because it was created at the time. It's not post hoc rationalization. But of course, a really APA-savvy law firm would be looking at that rulemaking record and trying to make hay. So far, so good. Any other questions? All right. Well, thank you very much. We are reminded by the wonderful CLE staff to please complete your evaluations, and you can leave them on your desk or out in the table in front. Thanks for your time today.